Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney client relationship. This communication may constitute attorney advertising.
Hi, AI Council Code listeners. Earlier this year, we recorded a two-part interview with Joe Cahill, an attorney in our Washington, D.C. office, on the draft legislation for the EU AI Act. Since our recording, the EU AI Act has passed in March 2024. And while my discussion with Joe considered the draft legislation, most of our discussion is still applicable, focusing on the legal framework and technical documentation required under the Act. Enjoy the discussion and stay tuned for more episodes. Welcome to AI Council Code. The AI Council Code is here to keep you up to date on all AI legal issues arising in the modern business frontier. I'm Maggie Welsh. I'm a partner at Baker Botts, and I co-chair the AI practice team. Today, we're joined by Joe Cahill, an attorney in our Washington, D.C. office, and today's podcast will actually be part one in a two-part series. So today, we're going to talk to Joe about the EU AI Act, what it covers, and generally how it's structured. And then in part two, we'll have Joe back on to discuss ways that companies can start thinking about collecting and preparing technical documentation related to AI systems to comply with the EU AI Act and why that's important whether you are in Europe or a company outside of Europe. So welcome, Joe. Glad you could be with us today.
Happy to be here, Maggie. Let's get into it.
Joe, why don't you introduce yourselves to our listeners and tell them your background in AI?
Yeah, so I am an associate in the DC office. My day job is patent litigation, but I really enjoy all the new AI systems that we're reading about, hearing about, and I have a background and fascination in AI systems ever since law school. I've been tinkering with these things and building them outside of my legal classes for some time, and it marries with my engineering background as well. So I have an engineering undergrad degree, and I've carried that technical interest through into my practice of law. And now I'm sitting here with you, Maggie, and talking about AI, and it's a brave new world we're looking at, and I'm excited for it.
Great, thanks, Joe. And one part of that brave new world is the EU AI Act. So why don't you tell us what the EU AI Act is at a high level for listeners that might not be familiar with what it is and what it covers?
Yeah, so this is from the European Union. It's their overarching regulation of artificial intelligence, and it's poised to become one of the first comprehensive legal frameworks for AI worldwide. It adopts a risk-based approach to regulation, aiming to ensure that AI development aligns with key safety, privacy, and ethical standards as defined by the European Union. It's important to note that as we talk about this act today, we just have the draft language. So it's in the process of getting approved, and we have a decent idea of what's going to be in the final language, but I want to put that caveat in as we go and discuss the content of the act itself.
So what AI systems are covered under the EU AI Act?
So I have a definition in front of me here. We're going to go over generally how it's defined, and then we'll get into more of what the guardrails are for what's regulated. An AI system is defined as a machine-based system that infers from the input it receives how to generate outputs such as predictions, content, recommendations, or decisions that can affect physical or virtual environments. Additionally, I will note the Act generally will not apply to AI systems used for military or defense purposes, or for non-professional reasons, or for research reasons. So there are some carve-outs to that.
So the EU AI Act that we're talking about, it's being enacted in Europe. Why should companies outside of Europe be looking at or frankly even really caring about the EU AI Act?
Good question. So of course, EU is a big market. So if you have a product that's in the EU market, it's going to immediately apply to you. But we have to think about the market effect overall. So even if you're just a US-based company or you just have a US focus, first we're going to think about producers of AI. Because the EU is set to bring online one of the first major AI regulations, many companies exposed to this market will begin designing for the EU AI Act's restrictions. These design choices may present themselves to customers all over the world and not just in the EU, because If I'm a designer of an AI system, I may not want to go and make a version of my product for every single jurisdiction and every country in which I put my product into. The other thing is governments. So other governments. When you have other governmental entities looking at this finalized language, they may decide to pass something that is near identical or something that kind of rhymes with the EU AI Act. So this is really going to be the first wave of what I presume is going to have ripples into the AI regulation space and the AI products that we use and engage with every day.
So that's really great point. So companies and government will all be looking to the EU AI Act because it's one of the first pieces of the comprehensive legislation that we're really seeing in this area.
It's going to be a reference point for us going forward. And folks are watching. So things that go well, I'm sure are going to be copied, and things that don't go well, they might be tweaked in future iterations of other governmental agencies and how they approach their own jurisdictions and regulation.
So the EU AI Act takes a unique approach in terms of AI regulation where it looks at the risk-based approach that you mentioned. Can you describe for us what does risk-based approach mean?
Rule of thumb, higher risk, stricter rules. For example, high risk AI systems, as defined by the draft language, will be authorized but subject to tougher requirements and obligations, such as the need to ensure specific technical documentation is kept by an organization that details how their AI systems operate and that they're compliant with the law. Overall, high risk AI systems will require extensive governance activities to ensure compliance. Now, high risk systems are not the only thing within the EU AI Act. We have limited risk and we have unacceptable risk as well. Limited risk are the things like chatbots. Those are the things that we don't really view as posing a huge threat. They're more toys or smaller tools that people interact with. The impact of those won't be as significant. Those are regulated, but not greatly within the language itself. Next, we have unacceptable risk. So the draft language says you can't do these things. And some of these include social scoring based on the social behavior or personal characteristics of a person, emotional recognition, and biometric categorization to try to figure out sensitive data about an individual.
Interesting. So there's uses of AI that the EU AI Act says just are not permitted.
That's right. So you can see the framework is very clear here. It's what impact are these tools going to have on society? We're going to try to label that impact and say, if you get to this point, you're being regulated in this manner.
What are some examples of the high-risk systems?
It's going to be a set of AI systems that create a form of harmful risk for people's safety or fundamental rights. An AI system will always be considered high risk if it performs profiling of people in addition. The Act will provide a definition of high risk, as well as the methodology to identify the high risk AI systems in the final language. But for now, I'm just going to say generally, it's going to be the harmful risk to people's safety and offending their fundamental rights.
So we talked about the limited risks, the unacceptable risks, the high risks. Where do things like generative AI fit in? Are those considered high risks or limited risks?
They could be considered limited risk if there's not much going on, saying, I want to interact with this cartoon character persona. I'm just going to have this chatbot. It seems like that one is probably going to be in a more limited risk. But the minute that you take the tools that underlie and you start to utilize it to make decisions within some bigger systems, such as a screening mechanism for processing large swath information about people, you're going to start to go into high risk because some of those concerns that the draft language talks about are now going to be implicated by that.
Are there any other interesting frameworks or general rules that you're seeing in the EU AI Act?
We are seeing direct language at what is called general purpose AI and foundational models. Foundational models are a type of generative AI system. A lot of folks have dealt with chatbots recently. That's a generative AI system. So you're to think about some of those underlying models that are running those tools. Those are considered LLMs, which is a text form of generative models. It is something that you can think of like a ball of clay. That's what these foundational models are. They're a big tool. They have a type of functioning, but they're a bit more broad in their scope. It's not just like a classification model saying this is a dog or not a dog. It is more open. You can use it however you want. Tons of folks use these types of tools in all sorts of ways.
And so there's dedicated rules for these foundational models in the EU AI Act?
That's right. So for foundational models, you're going to see dedicated rules that include drawing up technical documentation that shows you're complying with EU copyright law and providing detailed summaries of content being used for training of these models, for example. So that's one portion that we're seeing directed at the foundational models, but we'll see what the final text looks like exactly.
Okay, great. And so when the EU AI Act is enacted and fully enforced, what bodies are going to be enforcing this law?
Presumably in 2026, enforcement's going to be carried out by national authorities designated by the EU member states to supervise compliance within their territory, as well as a centralized European AI office tasked with coordinating these enforcement efforts. There's some specific bodies that are set out in some of this draft language. So first, we have this AI office that I just described. It's newly established. This is a product of this draft language, and it'll be tasked with overseeing the regulation at a high vantage point and contributing to fostering new standards and testing practices and enforcing common rules in all EU member states. We have a scientific panel of independent experts as well, which is going to advise the AI office about general purpose AI systems and on the emergence of high impact foundational AI systems, or what they deem are going to be some things, risks, threats that the AI office should really be paying attention to. We also have an AI board, which is comprised of EU member state representatives, and it will remain as a coordination platform and advisory body to the Commission while contributing to the implementation of the AI Act. And then finally, we have an advisory forum for stakeholders. So this will be set up to provide technical expertise to the AI board. This may be populated with individuals from the private sector to bring in some of the industry knowledge. So lots of different bodies, lots of different regulatory players as we go forward. I will say the AI office is going to be interesting. It's going to be that centralized authority that we can look to for some guidance on how to interpret some of this language once it's finalized.
What will be the ramifications for a company if they don't comply with these rules?
It's going to be similar to the GDPR for folks that are familiar with that law, but the fines are going to be calculated as a percentage of the liable party's global annual turnover in the previous financial year, or a fixed sum, whichever's higher. For example, we have 35 million euros or 7% of the global annual turnover for violations which involve the use of banned AI applications, 15 million or 3% of the annual turnover for violations of the AI Act's obligations, and 7.5 million or 1.5% for the supply of incorrect information in reference to things like the technical documentation that a company is going to be required to have on file if they're dealing with high-risk AI systems.
Interesting. So there's a different amount of penalty that will be enforced depending on whether a company has used a banned AI application or has just supplied incorrect information.
Yep, that's right. Generally, as is the framework of this draft language, the higher risk, more severe the offense, the higher the penalty that's coming.
Great. Thank you, Joe. Why don't you give our listeners a little teaser for what they should start thinking about and how they can start preparing for the EU AI Act now?
Yeah, so you got to see what you have. So start with an audit. See what technology you have within your company. See if it's in the products that you're already designing. See if it's within engineering teams. You got to understand what you have under the hood. And from there, you got to put processes in place to ensure compliance. It's going to be important to have buy-in from everybody as well. This is as much communicating with the engineering teams as it is compliance. And we'll talk about that more on the second part.
Great. Thank you, Joe, and thank you all for listening to AI Council Code. We're glad that you all joined us today, and stay tuned for Joe's part 2 series on how to prepare for the EU AI Act, and also additional podcasts and more insights on AI legal issues.
Thank you for listening to this BakerBots podcast. BakerBots has the experience, knowledge, and people to address our clients' most significant legal issues. For more information on BakerBots practices, please visit us at bakerbots.com. This presentation is provided by BakerBots LLP for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.